Well, today is day 2 of closing arguments in the sexual assault trial of 5 former World Junior players. Yesterday, the lawyer for accused player Michael McLeod targeted the credibility of the complainant, who is known as EM. McLeod, Carter Hart, Alex Formanton, Dylan Dubé, and Cal Foote have all pleaded not guilty to sexual assault for incidents that allegedly took place in June 2018. McLeod is facing an additional charge of being party to the offense. For a closer look at the arguments, I'm joined this morning by Kim Schofield, criminal defense lawyer. Good morning.
Yes, good morning, Emory.
Kim, first of all, what was your assessment of what was presented yesterday, and what can we expect to hear today when the final group of lawyers make their closing statements?
Well, throughout the cross-examination of the complainant, it became very, very clear that credibility, as often the case in these kinds of trials, is central. So credibility and, to a lesser extent, reliability of the complainant. The defense clearly takes the view that she's lying, that this is consent, and that this is the complainant taking what started out as a little white lie and turning that into this multi-year, multi-investigation process that also ended up with a civil settlement.
What does the defense need to prove, and what does the prosecution need to establish in order to win this case?
Well, the defense needs to prove nothing, but the Crown, so we start off with the Crown has to prove its case beyond a reasonable doubt. And part of that is proving that the complainant was sexually assaulted, i.e. that the act happened, the assault, and that there was no consent. And this is the problem. And from the very beginning of this case, the Crown started back when we had the first jury, the Crown started and said, essentially, put on the shelf your preconceived notions of consent, because we're going to challenge that. Because, of course, what we have very uniquely in this case is a video recording of consent. So the complainant is asked, are you consenting? And she says, in what the defense says, in a very dismissive tone, oh, of course I'm consenting. Don't be so silly, something to that effect. And so her position, when that was put to her, is that I said what I had to because I was paralyzed by fear, or I acted out of fear or out of being terrified. And the defense says clearly the actions, the evidence we've heard, the video, and the prior statements say otherwise. And that's really what they're focusing on.
Yeah, the crux of this case, as you mentioned, is around consent. And you're talking about one of those pieces of evidence that was brought forward was the video of EM saying that she was asked off camera, saying on camera, this is consensual.
Yes.
Kim, what are the biggest conversations being raised around the issue and the idea of consent?
So consent is something that exists in and of itself. So is she consenting? But there's also the element of, is consent conveyed? And is there a mistaken belief in consent? Although, be clear here, that's not the defense's position. The defense is clearly that she did consent and that she is lying about it. But what we have to look at is this something she could have consented to? Or is this something that the players should have known that she wasn't consenting to? Even in the face of her saying that she is consenting. But all of this really comes down, in this case, the simplicity is this. Is she telling the truth? Is she lying? Has the Crown proven beyond a reasonable doubt that she is telling the truth? Because the judge could say, I think she's probably not consenting, but the Crown hasn't proven it beyond a reasonable doubt. So this is a trial about legal standards. So it's not, the judge may, in fact, believe that she probably is telling the truth and still acquit the accused, because it's a very, very high bar. It is proof beyond a reasonable doubt. And the reasonable doubt is not absolute certainty, but it's the layperson's way of saying, I'm sure this happened like she said. And it'll be interesting what the Crown says, because the Crown submissions are going to be lengthy, but how they're going to try to convince Her Honor that she should be sure that the complainant actually did not consent in this case.
Kim, last question for you. The accused have the right to choose their trial by a judge or a jury. They chose jury. Both of those were dismissed. The trial continued with a judge alone. How could that shape the outcome of this case or what happens afterwards?
Well, I think it shapes the outcome because we will clearly know why. So because a judge has to deliver a verdict, and it is not a quick, speedy verdict like a jury, the judge doesn't go behind her chambers and thinks and then just comes immediately back with a verdict. That's what happens with a jury. So with a jury, there's more quick certainty of verdict. But with a judge, she will take some time. She will write a decision. We will understand her reasoning. We will understand why she comes to the decision she comes to, and potentially a much more helpful decision in allowing everybody to move forward, because we will understand why. And then maybe the Crown appeals, maybe the defense appeals, but the decision will be written and it will be available for everybody to understand.
Kim Schofield, criminal defense lawyer, thank you for your time this morning.
Yes, thank you. Have a good day.
You too.
If you like that video, make sure to subscribe to the Your Morning YouTube feed, where you can find all kinds of new content posted every weekday morning.